All right. Uh, we're back. Thank you for those of you who are still with us online. We got a very dynamic panel coming up. I'm gonna pick this high break here. We can't thank our sponsors enough. Without them, it's not possible. So we want to give a huge shout out Brett Stewie, Wilmer Hale, Reed Smith, Greenberg Trarik, Ice Stiller, Verizon, and Block for making this possible. I am going to turn this over to you. Got David, Diane, and Leah. I hope you guys are ready to take some notes. I'm going to turn it over to them as they introduce themselves and we're waiting on one minute. But remember, in the beginning lawsuits, I told you, if you want to work in the IT and tech world, it behooves you to get comfortable being comfortable, being able to adapt in a fast case environment, because you can't control everything, and you'll be owning very quickly if you can't tolerate things being out of your control. You need to be fully in control of everything. You're gonna learn quickly that life will laugh at you, and you will find yourself stressed out. We don't want to stress out. So without further ado, join me in giving a round of applause to our next panel.
Good afternoon, everyone. Thank you all for being here. Like Charlie mentioned, we're still waiting on one more panelist, Meagan, but Rick, sorry, that's all the rest of well, yeah, thank you guys for being here today. I'm very excited for this panel titled Driving Tech Entrepreneurship and Innovation. We have a great group of people here, very dynamic. They've all had experiences from different angles of the industry, so I'm just excited to hear what they have to say. We're going to be talking about sort of, the strategies and developing and advancing tech industry, and specifically focusing on some IP assets too. So, in order to solve a little bit, why don't you guys introduce yourselves, share what you do, where you work, and what got you interested into the tech and IP space?
Good afternoon, everyone. My name is Julien Bowers. I'm a partner in the technology, transactions, and privacy group at Perkins, Coie. What do I do when I'm not saving the world? I have a very wide-ranging technology transactions practice. Spend half my day doing strategic IP-related collaborations with established players like Microsoft and other big tech companies. Sometimes that looks like a big company coming to me and say, hey, we've got a fantastic idea. It could be everything from cloud-based gaming ideas. I do a ton of AI-related ideas. That's not a secret anymore. And I can say this, our firm was involved in the Microsoft OpenAI chat GPT deal. So it's never the same. Yeah. And then on the other hand, I represent ECVC and startup type clients, folks with platforms and technology and really good ideas, but they need help establishing their overall IP strategy framework. And those are some of the types of transactions I like the most, because you get to really guide people before at the beginning and navigate them around potential mistakes that could evolve when it comes to overall IP development. Funny story. So you asked what got me into tech trans. I was a poor law student, and I was really just looking for a job when I graduated from law school. And I started off, so the job that grabbed me was being a corporate attorney. And so it was fine. But after about a year of doing it, I realized I didn't love it. And if you got most people, if you love something, you're going to be better at it. And so the aspect I liked of it was the contract drafting and negotiation piece. I just didn't like the topic, and I was always interested in technology and IP, generally speaking. And so was able to navigate my way to being a technology lawyer, which is a combination of that. So I still negotiate and draft contracts, but they're all tech or IP focused.
And good afternoon. I'm Trevor Jefferson. I most recently been of counsel at Quinn Emmanuel, where I did in the narrow niche of the world, the patents, to go back to the Patent and Trademark Office and get challenged before a board there. You can, once a patent is issued, it used to be it had to march out in the world and be adjudicated to sort of figure out what it meant. The patent office had a few procedures where you could send it back to examination. The board that I joined, thanks to the American Invents Act, said you can come back and have a mini trial at the patent office, and it might decide if your rights are good or not. Going further back, my former boss is in the audience. I was a civil justice department trial attorney doing intellectual property disputes. The government is a user of and creator of intellectual property and has a small statute that lets you bring those challenges to the government's use, and largely I did defensive patent law on behalf of the United States government. Before that, I was an associate at Latham and Watkins, where I tried to do as much as they would let me do on commercial litigation, patent litigation, where I got the bulk of my experience, transactional work, trademarks, ICANN disputes about domain names. I did anything then everything they would let me do when it came to tech transaction, because I wanted to be a part of that world. And that leads me to the next part of the question, which is sort of how I got here. I was an engineer before I was law school. I went to the great university known as Howard University, here high on Hilltop High, as a Howard engineer. Very proud to be, let me say I'm very proud to be doing anything for my alma mater. I think almost everybody who goes here understands the special place the school operates in when it comes to our nation as well as in our hearts. So I'm happy to be back here. But I went to grad school after that, and what I used to joke was a failed attempt at a PhD. I found myself doing a little bit of work. I did satellite work for about a year and a half for a no longer existing GE satellite builder. And then after that, I went to Motorola and worked on cellular systems, which little did I know would become the sort of digital commons place that we spend most of our time on. I mean, I think everybody in here has been on their phone at one point in time, and that it's been exciting to be a part of that industry. And the thing that attracted me to not just patent law, but tech law in general, is that technology sort of pervades everything we do, much like law sits at the cross sections of everything we do. I think I literally wrote that in my law school application too many years ago. But it's everywhere, and yet the rules of the road and how we interoperate with it are not clear. Every day, I was fascinated by the last panel. I did not know there were that many data rights issues that went on in the sports and entertainment world. But of course, it makes sense. I mean, beyond the copyright licensing and things that I thought I knew about, they are dealing with a mountain of data that they create in what is easily the largest entertainment structure in our country. So I was attracted to those hard problems because I think they are the same problems that go on in other parts of law. There was a panel earlier where someone was talking about employment and other information, same issues, just a different level of the hierarchy, but they're all there. Someone talked about farming data and agriculture. There's, again, technology invades those issues, but they are still at their core legal issues. And that's what I found very attractive and what keeps me involved in this space. And then frankly, now trying to make sure I expand my skills in that area. So that's what I've seen. And frankly, the litigation aspect of it, I was worried that I didn't have the same transactional experience that my panelist here has, which I think I see why he's excited about it. It is interesting work. The problems are always new. But litigation is where we discover what those problems mean, where we put money to the problems, with the remedies to be made whole, or the specific performance that almost everybody wants when they go to court. And those are the issues that I think about and animate and have discovered I have a wealth of experience in understanding what I think the parties in those litigations wanted way back when they started at his table talking about a transaction.
If my contract ends up in front of you, then we're in a world of hurt. But it happens.
Well, it does happen, and it happens because contracts and technology themselves don't answer all the questions, right? There's human beings, there's desires of what people want. I was talking with my old boss about a lawsuit that happened that I was asked a few questions about at the law firm at Quinn Emmanuel. And the purpose of the lawsuit, it's a patent litigation lawsuit, had nothing to do with the actual patents. It was about one party feeling another party was misusing the technology in a social way. That's not what's on the complaint. That is not, it might be sort of in the background, but that's not what the complaint is about. It was about patent infringement and the right to exclude. And as a lawyer, litigating lawyer, you have to understand that. As a contract lawyer, you got to understand that's a potential possibility of what your client wants. It's a fascinating world.
Yeah, well, see, as I'm with ITP, these are the experts here. They know what they're talking about. I realized that I also didn't introduce myself. My name is Kiara Ortiz. I am co-founder and executive director of LegallyBlack, and our mission is to first share BC intellectual property discourse in scholar. By day, I'm also a legal advisor. This gentleman actually I am a legal advisor to Commissioner Jefferson, the litigation Julien books on telecom issues and media issues. So now we have Meagan. Hi. Hey. I'm gonna put you on the spot now that you're here.
Absolutely.
I just asked everybody to introduce themselves, share what you do, and what sort of brought you to this tech space.
Absolutely. Hi, everybody. I'm Meagan Sunn. My apologies for running late. I'm an up counsel at Ice Miller. My job is a little half and half. So I'm a regulatory lawyer, and my specialty is tech and IP. And I'm also a federal lobbyist. So apologies, I was on the Hill actually dealing with issues from the last panel around NIL. So I came to this space originally because I was interested in entertainment and was actually interested in soft IP. I came in contact with an organization called MMTC that really focuses on the intersection of social justice and tech policy issues through my work with the Florida NAACP. Ended up here in DC, worked at the FCC like Kiara, and the rest is sort of history. So really looking forward to having an engaging conversation and really excited to join this really highly esteemed panel.
Yeah, thank you. So let's just start from the beginning. When starting a tech business, or just any business, really, just in this tech space and in this digital landscape, there are so many factors and considerations that you have to think about, and you guys all touched on some of them. Trevor, I want to start with you. For those who are out there developing new technology, when should they start thinking about patent protection, and what strategies can they employ to safeguard their innovations?
I'll try to be brief and direct, which is patents are just not self-executing rights. When a party thinks about developing a business or a concept or an idea, where you fit in the landscape of your service, business, product, where you fit in the landscape of the technology that exists, determines the kind of protection you need to go for. Maybe it's know-how, maybe it's skill and expertise. Maybe there's clearly should be maybe a patent area. There's clearly what, I don't like the word soft IP, but copyrights, trademarks, things like that are very important. I mean, judging by the amount of money we spend on NIL and things like that, I'm guessing they might be the most important. So there are all sorts of aspects you have to think about, and you've got to think about them early. And what if I would, when I thought about this question, Kiara, one of my first points was most of the litigation I thought I saw, whether it's on the board at the PTO or when I was working at the DOJ, were people who got IP rights and thought they were something that they were not. You know, I have a patent, I lost the contract, the patent shouldn't protect me, and I should be the only person to do the contract. Well, my job, as per my former boss, was to read your patent and to tell you it didn't cover what you thought it covered, right? And our job was to litigate that to the fullest extent possible, and almost always the mismatch, managing that mismatch and getting the other party to see the limits of what they thought they had acquired was clear. Same thing when I got into the Patent Trademark Office. I had one of my first cases, actually, that I remember was a David versus Goliath story. Someone who had created a great product that was great at, I think it was leak detection at chemical and oil refineries. It was the use of great old technology to do something in a small way that people spent a lot of money and couldn't do in a great way. And their good enough solution was great. Their patent was not. And when I was on the case with a very old gentleman whose name I'll mention because my old former boss knows, John McKelvey. When I told him, I said I felt bad for the party that was losing, he said, it's not your problem. His patent attorney let him down. And he was right. The patent just didn't cover what they thought they covered. It could have. It probably had the seeds of doing it. And so what I would tell entrepreneurs or innovators or people out there is it's very easy to find someone out there who will file a patent for you and get it issued. Very easy for someone to write a good plan and tell you what the secret is so that you can write it into this guy's contract. Very easy to find those things. It's very hard to make sure they are good, to constantly reevaluate what that thing is. And maybe your great idea is not as protectable as you think, but there are aspects of it that can be. So what I would say to people is you think about it early, try to find resources to help you figure out that what it is, and constantly reevaluate. Once it's written and filed and you've walked around and gotten seed money or gotten investors and told them it's patented and it's buttoned up, it's not patented until it's tested. Until it's litigated, till it's tried, till it's tested against the world, till your contract has to be licensed or you have to deliver. It's not tested until that, and so you should constantly reevaluate that, just like you reevaluate your business. Things change over time. So I try to be quick, but I think the idea is think about it early, understand the bundle of rights that you're given, and just don't take the fact that it comes out of the office with a seal on it or someone has told you this is what the trade secret is, or this is what the protectable IP is. You have to constantly and vigilantly guard that area.
Yeah, no, that's good advice. Good advice. Definitely thinking about it early and making sure that you take the appropriate steps to protect yourself. Julien, for your experience, for startups, let's just say looking to scale from more the transactional side, what are some of the key transactions or types of deals that one should be thinking about in maximizing the value of their IP?
So IP is interesting in the fact that it is an asset, obviously not a physical asset, but like any other asset, there are ways that you can monetize it without giving it away, so long as you ensure that you own it. And so, what are the ways a couple things you should be thinking about, right, when it comes to IP? It's prioritizing transactions, about the creation of that IP, the protection of that IP, and then finally the monetization of that IP. And so what does that look like in the real world? Imagine a scenario where you created an app, it took off, became really popular, but you hired a third party, a vendor, to develop the source code for that app. Well, that source code is copyrighted material, and there are just unique default rules under every jurisdiction, and I mean the U.S. and foreign jurisdictions when it comes to IP ownership. So under the U.S. law, whoever is the author of that work of authorship, in this case being the source code, they own it, and they've got to affirmatively assign it to you, like a written assignment, and if they don't, they still own it. So to bring it all home, in that scenario where you didn't protect your IP, you've got a situation where you paid someone else to create a valuable app. You thought you owned the app, but the actual IP to that app is owned by the vendor, and you can see the ramifications that stem from that. So, what do you do about it? You just give some thought to making sure that the contracts that you're using with anyone who is developing your IP is correct when it comes to IP ownership and follows the rules of the road. And then with regards to the monetization piece, I said you can monetize your IP without giving it away. Just one example is you could enter into licensing agreements with other folks and allow them to sell your IP, and you get a share of the revenue, but you're not giving your IP away. And you can do that for a set duration or perpetually. It's up to you, but you're still the ultimate owner of that IP. So I've seen scenarios though where real world cases where companies that became well established and multi-million-dollar companies didn't dot those I's and cross those T's initially, and then when it came to the exit, they were ready to sell, and someone like me comes along doing the IP diligence, and they found out, going back to that initial scenario, wait a minute, some other third party created this application, they own the IPs, and so what's the effect of that? It might not kill the deal, but it might crush the valuation of your company. So there are some real world risk that comes with not thinking about those types of issues initially.
Yeah, definitely. And in your response, you mentioned some of the challenges with differences in jurisdictions. And so, like, as tech businesses, most of them, the goal is to go global, right? What sort of other challenges have you seen in protecting IP in cross-border, like, mergers and acquisitions?
It's I was on the call today. It it could be anything from data is another asset. Sometimes there's certain tech and IP that other countries are just more strict about, and they'll say you can't, regardless of what you write in your contract, you can't export this valuable data or IT outside our jurisdiction. And so, could be a scenario where uh, like the company was doing that and they didn't know, and then there were some fines from regulators that came from that. It could be another scenario where the foreign jurisdiction has we have U.S. copyright law, they have their equivalent of that, and it says, I'm making up something, but it says you gotta you gotta have the written assignment and do it in this is an example, but do it in 7 pages or it's not effective. But there are a bunch of rules in every jurisdiction, and so if you're not careful, and in that scenario, even a person like me that does this every day, I would get local counsel to check my work and to make sure there weren't any default rules of the road that I needed to abide by. Because again, there are countless real world implications that come from not doing them.
So in talking about like growing a business, obviously securing funding and, navigating college or discriminating stays, same word I have to say to that. Meagan, government funding programs, often focus on innovation. From your experience, what should entrepreneurs or small businesses be thinking about when they're seeking grants or the subsidies for or from any sort of funding for public sources?
Absolutely. So I think, so part of my experience also on Capitol Hill was the Tech Council on the Small Business Committee. And what I saw a lot of was that folks that look like us really aren't aware about the billions of dollars that are spent on R&D and commercialization of technology in this country. For many years, a lot of that funding went to a lot of the R1 institutions that are PWIs. I know that most recently, Howard University recently reached R1 status, which is amazing. And I think really opens an opportunity for the scientists, the folks who have some of those engineering degrees to match up with the attorneys and the MBA majors to figure out how to bring together the technology and the commercialization. So one of the first piece is understanding the landscape of the resources that are available to you, and also understanding what your strengths are, right? Like not every scientist is necessarily going to know how to best monetize technology. I know that, in your practices, you often deal with both, and they kind of speak different languages, right? So a part of the work that I also do is around the economic development in cities. I represent a number of cities and also the African American Mayor Association. In the last administration, there was a very large piece of legislation called the CHIPS and Science Act, which effectuated regional technology hubs. So in several different cities, including Birmingham, Alabama, also in Tulsa, Oklahoma, as everyone knows, that is the site of the massacre. There are tech hubs that are funded by the federal government, and the folks who are at the table are stakeholders that people in regular communities have access to. A lot of times people think you have to contact like MIT. A lot of times they're community colleges that have upskilling programs around emerging technology and bring together people, and also large corporations to fund certain projects. Another piece I think I just want to highlight is that I know there are broader conversations about the lack of representation in venture capital, how I think it's like less than 1% of, I think, women-owned or Black-owned entrepreneurs are funded by venture capital. At the SBA, there also has been a lot of relaxing around some of the funding mechanisms in the Office of Innovation, and also the SBIC program that provides really early seed funding to a lot of technology startups. So those are all opportunities that I think people just need to be educated about and understand that there are local resources, not in DC, but right in your community that can assist you. Last thing is, I think on the back end, just understanding, there are strings to federal money. I think a lot of mistakes, and you might have dealt with some of this, is folks don't realize there's an auditing process on the back end. So, it's wonderful to have a great idea, but I think really understanding your numbers and understanding how you're going to monetize and work through a project and show that return on investment is important as well.
Yeah, no, that's really great. And anybody can answer this. From your guys' perspective, what makes a business attractive to investors outside of some public sources of funding?
Are you saying as to initially identify them, or is it more of when someone they think they're interested as far as the process?
Yeah, sort of in the beginning stages. If I'm somebody who starts my own business in this industry and I am looking to secure funding, how should I make myself more attractive, I guess, to investors?
I see. I think just of course I'm going to speak from the lawyer perspective. Yeah. There's obviously the business perspective of this, and I mentioned that as a small business owner also. But from the lawyer perspective, I mentioned earlier how there could be issues with IP ownership, and then that just plummeting the valuation, right? Same thing could be true when it comes to whether or not you get money initially, because what's going to happen initially, say you're in startup mode, you give your pitch, the business folks are going to be interested, and they're going to say, hooray, yeah, we're interested at X amount, and here's the money we're going to invest. After that, what happens in the real world is their lawyers start the diligence process, and as part of that, they're gonna ask for every key contract and other agreement that you startup company who's seeking money has entered into to develop in connection with the development of your IP. So that includes the bag contract I mentioned earlier, and it also includes contracts with your employees who might have also been involved with the creation of IP. And so as part of that process, if there are gaps in what you should have done, you're not even going to get to exit, because if you don't fix the issue, because folks aren't going to be willing to invest.
Yeah, definitely.
I think the foundational point that I talked about earlier with knowing your IP and knowing means also knowing your space, right? So I mean, when founders and entrepreneurs are doing pitches or building the layers that they think they then want to get investors involved in, you have to have done the homework to know the landscape you're operating in, the people you have. Sometimes the know-how you have is your real asset. Understanding what your real asset is and what you're pitching, because at least from the folks I've talked to, and I've talked to litigation funders and some venture capital folks, people I've worked with over the years, some who were engineers with me back in the day, and they are, man, I hate to use the word shark, like Shark Tank, but they are like blood in the water. They know exactly what to go for to find the weakness and whatever there is, because they're not going to put up their money unless they think they're getting their return. And so it doesn't surprise me the diligence, what looks like a good idea, the diligence itself could fall apart. But you conquer that, I think, by knowing a lot about your space, knowing a lot about your deals and the people and the know-how, and then hopefully having done the homework it takes to have good deals and things in place.
Yeah, definitely. Now shifting to the regulatory landscape, what, and Meagan, you can probably start because of your experience, but what do you think are the most pressing regulatory challenges that face the tech industry today, especially in light of emerging technologies and AI, where there's sometimes no regulatory framework or very patchwork regulatory framework? What do you think is the most pressing challenges, and how can people sort of keep up to date with what's going on?
Absolutely. Very recently, they've had the confirmation hearings for the White House OSTP office, as well as the FTC. There's been a lot of activity also at the FCC, but I think, that broad strokes in terms of themes and where I think this administration is really focusing on regulation, I think is obviously kind of picking up where they left off on building out an AI framework. The last administration and Senator Schumer, as well as Senator Young, so it's sort of a bipartisan effort. I know that they were looking at a lot of trying to develop key principles around AI regulation. I know that the White House and overall, not just in the tech space, is kind of consolidating a lot of power within the White House. So where an expert agency like NIST might have had a lot of influence over AI regulation, I think a lot of that's going to be centralized in the White House. There's also a lot of talk around big tech and a lot of issues around censorship. I know that's going to be very active at the FCC. I also think competition globally is a huge topic, particularly around quantum computing. So I think that's going to be a major area of focus. And then lastly, kind of more on like the electronic side, I'm thinking about like rare earth minerals and other resources. I think policies around like tariffs and some of those geopolitical issues are also really going to shape the tech conversation. And then just lastly, sort of on the telecom and on the streaming side, there's going to be a lot of conversation around spectrum allocation, and spectrum obviously is what we use to make calls over cell phones. And, it's really beyond just voice communications, really anything that communicates. So a lot of the tech that we're seeing a lot around, as Internet of Things really starts to take shape is dependent upon spectrum. And there's going to be a large conversation around really freeing up some of that public spectrum that's at the DoD and making it available for public use. So I think those are kind of like the major issues that are being teed up now, but we're in such uncertain times. That could be the flavor today. We don't know what's going to be happening tomorrow.
Yeah, no, definitely. And, we could talk about that all day long.
I didn't mean to cut you off. I was going to say super quickly, I'd be remiss if I didn't talk about Gen AI and some of the newly enacted regulations related to that. I mean, we have a few state regulations, but I think most people are familiar with GDPR, which is the EU's privacy framework that set the standard globally when it was enacted.
Someone isn't. Little.
Yeah, sure. It's the privacy law in the EU that governs the collection and processing of personal data of people, and it says if you don't comply with it, you big company, there are monstrous penalties that come from it. I forget the total, but I think maybe 5, whatever. It's a percentage of the global annual. The penalty for non-compliance for a company is a percentage of the global annual turnover of that company. So and there've already been fines in the hundreds of millions of dollars. So it's not some theoretical law. It's a real thing. So fast forward to today, the EU has enacted an AI-specific law that's similar in penalties for non-compliance related to these powerful Gen AI models.
They keep getting ahead of it.
Yeah, they are. They're on it. So they've explicitly prohibited certain certain uses of AI that were just against public policy. They just outright banned. And then others, they said, okay, if you want to use these powerful models like Chat GPT type models for certain things like related to infrastructure, then there's testing and evaluation involved, and you can't bring them to market until you get the regulators' approval. And so, and the reason I mention that is because, again, like GDPR, that company, you don't have to be physically present in the EU for it to apply to you. If you're putting your products in the market, right, you are still governed by that, and a lot of folks don't really get that. So
no, definitely. Going back to something that you mentioned, Meagan, obviously we're in unprecedented times, and we don't know. I don't know what's going to happen, honestly, especially with this administration. What role? I mean, you've been very, very passionate about advocating for equitable access. What role do you see social justice playing in the future of tech law? Like, how are we going to be able to serve underserved communities, and what should, I shouldn't say what should the administration think about, because they're not really thinking about it, but sort of how should we navigate sort of this administration's approach to sort of undo all the work that we've been doing?
Yeah, I mean, obviously with the DEI order and this chilling effect we're kind of seeing with large players around some of the efforts in hiring and bringing folks into opportunities to work in tech as employees. I think it's really just getting active and organizing. Like, people got to get off Twitter and like get over the outrage and start doing things in their communities. I was just at a reception here in DC for an organization called the Benjamin Martin Foundation. They're working on raising funding to upskill folks who are non-traditional. Maybe they had been incarcerated, or they're in a rural area, or college is not for them. Trying to figure out ways to upskill them around AI certificate programs, right? I feel like everyone could do something in their space, in their place, and stop kind of like looking for like someone else to do something, and stop talking about like what's not happening. I feel like that's a key to what I feel like we need to do going forward. Yeah. I feel like ownership and really having a seat at the table, getting educated, prioritizing technology, because it's involved in everything we do, and even in media as well, right? Like the way that ideas are flowing, and how, even the restriction of those ideas that we're seeing in our current environment. I think that everyone has a part to play, and it's important to get organized.
Yeah, definitely. Good answer. Okay, so before I turn it over to, we have any questions for the crowd, I do want to touch on litigation. I know we talked about this earlier. It's not always a place where we want to be, especially when operating your business, but it's often inevitable. So, this could be a question for any of you guys, but what steps can a business or an entrepreneur take early on to mitigate the risks of litigation? And we touched on a little bit, but maybe specifically to your experience.
Litigation is a costly and draining endeavor to go through, right? I mean, nobody starts a business or goes into a deal expecting to deal with not what I call failure, but a problem that requires people to have someone else to resolve their dispute for them. Having said that, and I want to tie it to what we talked about in the current uncertain landscape, is that there are certain foundational ideas that are out there about what the value of IP, or the role of regulators, or lack of role of regulators when it comes to these kinds of things. And so entrepreneurs by nature seemingly are not risk averse, but need to start to think about how do you manage the dissolution of something. And I think the easiest way is by building a great fortress, by knowing your competitors, knowing your landscape, knowing the regulatory landscape you operate in, and the potential changes that can come from it. And often, as I think I've tried to hit more than a few ways, what people think of as their innovation, what people think of as the role of their business or service or whatever, the actual thing that is generating the power is not the big idea that they think they are protecting or working with, right? I mean, it's something else, and understanding what that core thing is and protecting. And with that in mind, sometimes you're just going to have to, litigate and go that way. But if you are wise and have thought about it, you will know going forward the limitations of the tools that you are using to do it, right? I mean, if you were depending on a government contract, if you were depending on a licensee situation where you don't have the capital or the distribution, but someone else does, what's your relationship with them? Who has the rights to maintain, sue, go forward? All of that matters, in your ability and relative position within those negotiations decides where you sit. And again, back to that point of reevaluating. Maybe at the beginning you were just trying to find an exit strategy, but now you see someone is misusing your IP and your licensee is not out there doing anything about it. Sure. You want to march in and do something about it. You got to ask this guy if it's in the agreement to begin with.
Hopefully.
Right? You got to understand the regulatory framework, because maybe the licensee is so big and so ubiquitous that they are the ones who actually have the public face, and it looks like you're attacking someone who's doing the work. These are complex issues, and again, none of that is about the thing that's in the complaint that has a line item, that has a prayer for relief at the end, if you remember your civil procedure days, that says what you want at the end. I guarantee you none of the things I talked about are going to be in that list. None of them. It can be money, it can be performance, it can be something else, but it's not in there. So if you want to protect yourself and mitigate that risk, you got to think about it before you get to that litigation, because litigation is the last place you're going to solve those problems. You're going to get a resolution, but you won't solve those problems. Yeah. So that's why I'm actually more interested in like the front end and how you get there, or the regulatory scheme that you find yourself in that could shift tomorrow. Right?
I will quickly add on the front end, because I think that's important. When you're in startup mode, especially, you are money's tight, right? You gotta prioritize like what's key, and so sometimes what gets lost in that process is some of the nuance. I won't go over them again, but some of the nuances that relate to IP that if you don't cover, it leads to problems. And so it's you've got to, that's one where you got to give some real strategic thought to, and not just pull a contract from the internet without any knowledge of how that contract, who drafted it. Yeah, they do.
Especially if they're tight on money.
And that's an issue. And if you are going to use a form, again, understand, maybe even at least spending a little bit of money to go over someone with subject matter expertise to ask them, is that form okay, or are there any gotchas in there, because that could lead to issues. And especially, I'll give you another example. If you're like some real world liability, that if you don't cover it, it could lead to real world harm. If you have a contract with folks and it doesn't have standard risk allocation provisions, like limitations of liability, indemnification, and it doesn't limit the company's damages for things like data breaches, they happen all the time. And the costs related to data breaches, if you just say you're a vendor and your client is Google and there's a data breach, then the contract says you got to indemnify Google for all the damages and costs and expenses and attorney fees related to that data breach. With no cap, you are out of business. Yeah. And so that's why it's critical that those key aspects of the contract. If you've got IP covered in your contract and you've got the risk allocation provisions, right? I mean, I hesitate to say as a lawyer, you're mostly home, but that's 1,000 times better than those are the key things that I think you could, if you're in startup mode, you've got critical things that you've got to prioritize, make sure those are right.
Yeah. I'm actually interested in knowing from your experience, because you were an administrative patent judge at one point, and so has your perspective on navigating litigation changed? Or I'm sure it's different, but from that perspective of being a judge and now working with clients in the space, like, how has that experience been?
I think I've hit on it. It's I'm saddened by the number of folks who find themselves on the losing end of something that they think they righteously should have. Yeah. And I know it's there's no crying in baseball. There's no feelings in patent law in the sense. I had a good friend who told me he liked patent law except for the patents and the law part. He was a securities attorney. I don't understand how that even applies. But I found myself. That's why I'm thinking about the people who were let down at the very beginning of the process. And you think I'm talking about small entities. I'm not talking about small entities. I've seen it with large entities who are angry or have felt they've lost an opportunity or a business. When they're at the government, it would be a contract. But you can see in their work that they think they own a space, or they have the right to exclude, or the right to practice their invention in silence. And that's just not what the property grant says.
Yeah.
And having said that, at the law firm, I was involved in a few cases, and they almost always had trade secret components. They were former licensee-licensor relationships. They were on a development contract where somebody was testing their technology, and then a year and a half later are releasing their own version of the technology. Like night follows day, somebody thinks somebody stole my stuff. Yeah. Right. And invariably, those are contract claims. They might have a little patent stuff, but they are really what they are frustrated relationship things. And so as a litigator, what I think about is, they can find you some talented litigators who can win you some of those cases. Yeah. They'll win the prayer for relief part. What they won't win is lost business or opportunities. And I think of those middle tier entrepreneurs who really do feel like the big guys have all the power and they have very little. And that's whether it's, for communities of color or for small entrepreneurs or women who are starting out in a space, they're surrounded by folks. I can feel for them, but the fix for that might be finding high quality folks who can look at your work, guide you through as your business changes, how you build up your protections. But the truth is, almost all of these conflicts are of people who came together for a good reason, to make money, to expand a business. And invariably, when it falls apart, what people are left arguing about is the dregs and usually these intellectual property.
Yeah, no, definitely. Well, I want to open it up before we get you kicked out of here. If anybody have any questions, yeah.
I'm going to try this without that. I'm curious about Handler Sauceborn. The new interpretation that allow for the piercing of section degree or unique social media platforms. Any applications do you see coming for the ID law with respect to the commitments of the curation of platforms algorithm such that with no proper really cold state, sections 30 covering the flat and what it's here proposing. Wonder if we see any ID applications for hacks now. We given a landscape and gillable hydro capital, but actually, sort of weighing cut that overlay has been created, given the purpose understanding of the affirmation of the algorithm sheet has person speech, and now that we get to so more by building possibilities for social media platform.
Do you want to do? Are you familiar with that one? Or?
You can. I can add on. You have just some initial thoughts.
Yeah. And so for those who couldn't hear, the question was about Section 238B liability, which the short version is if you are, this is an example, if you're Meta, right, or Facebook, and you are hosting platform, the law said, or at least the state of the universe has been since forever, that you platform provider that's just hosting the platform, you got all these users on there and they're creating accounts and uploading data and making posts. And the law basically said, if all you're doing as the platform provider is providing the platform, then a third party can't come along and sue you for what your users posted. And then there's been some, that's been the state of the land of the law for what seems like forever. But there have been folks who have argued that the law should change, and if hosting platforms take certain actions with regards to manipulate is the wrong word. Speech content. Yeah, it's speech content, and it's getting involved in doing anything other than hosting the platform, and whether or not that anything other should make the liability go away. And I don't actually have. I kind of wanted to explain the lay of the land for the folks in the room. I wish I knew where that was going to go. I just feel like with every administration, politics is what's going to obviously affect that is who's in the White House and who's in the Supreme Court. And the White House is obviously, we know how much that changes. But even with regards to the Supreme Court, it's so far right now that it's just an unusual number of conservatives on the court. And I feel like Section 238 has been attacked from both sides for different reasons, but from people on the left and from people on the right. And so for me, because of that, it's a little hard for me to kind of guess what's going to happen tomorrow. But do you have any insights on?
Sure. Yeah, that was a very good lay of the land. I think obviously, like you said, both sides, there's been a lot of conversation. It's very clear from all conversations that I've been having, like, for example, in the hearings that I mentioned for the director of the White House OSTP, at the FCC, for several senators in the Senate, on Senate Commerce, the Committee of Jurisdiction, that they are very focused on political speech potentially being moderated by those platforms. I think where your question sort of sits is like what implication around like IP and like the development of like language and AI and algorithms and what that looks like. I don't know. I think that, we kind of saw what folks online are calling like oligarchs row at the inauguration, but that we're also seeing a lot of conversation and a really strong sort of populist movement within the higher ranks of senior advisors at the White House and throughout the administration that are concerned around censoring and all of those things and sort of peeling back some of the protections that big tech companies and platforms have been enjoying. So I think it's early days, right? I think that it's definitely going to be a part of the conversation. I also think it's sort of a political football, as he mentioned. It kind of depends who's in office. Another issue like net neutrality, right? Where, when we have the Democrats and we're pro net neutrality and we see it get peeled away as soon as the Republicans comes in. So I think it's going to continue to be a topic of debate. But I would really be interested to follow that line around the algorithms themselves and how that's going to impact how they're protected by attorneys like Julien and Trevor.
Yeah, I think it will. I mean, I think the real question is how. So, and I don't know the answer to that. I think we'll see in this administration, definitely some movement because I think there's just a lot of talk about what to do with Section 230 and how to apply it. So I think we'll see it soon. I don't know either.
I'll take a stab at the hypothetical in the sense that I think that I could see a law exam kind of question spinning out of this, which is you don't see a lot of litigation about the underlying algorithms for these social media sites. And if anything, they seem to be what people, at least the user experience, thinks is the special sauce that makes TikTok different from Instagram, different from YouTube Shorts or whatever other video platforming service there is out there. I think anytime you see a crack in the wall of that stuff, there's someone out there willing to litigation finance or fund a way to get at them. That one thing that patents have become, I specifically I work in the world of patents, but I think litigation in general it's just another asset, monetizable asset that people have been investing in. And I wouldn't be surprised if there are folks looking to pierce the veil to figure out how I can either monetize by attacking for liability or for ownership. Some of the things that go on behind the veil. And the one thing you're probably talking about, because whether it's driven by politics or other needs, is that if we're going to go and start policing platforms, how they do and what they do, which is almost always automated by some kind of algorithm these days, AI-driven, knowledge-based or programming, is a tackle. Right? It's going to be out there in the open, and these are huge entities, the largest corporations we have. It could be interesting to see if someone decides to maybe board plaintiff lawyers who don't have anything to do might be taking them on.
Good question. Anybody else has any question? Okay. Well, before we go, if any of you guys have any final words of
Can I take a stab?
Yeah, definitely. Go ahead.
Thank you, Kiara, for leading, gathering us together, leading us, drafting our concepts, and helping us put this together.
Oh, of course. Thank you to Charlie and the summit for hosting this. I think these are all important conversations.
Thank you all for dedicating your time and for some of you giving up some money